All right. Good afternoon, everyone. So my name is Chris Tavner. I'm General Counsel at the Ohio Environmental Council, and I'm really excited to be joined today by Justin Newman and Dave Altman with the AltmanNewman law firm to talk all about the Ohio's air nuisance rule. So, for those of you who may be new to OEC's Law Center webinars, we host quarterly webinars to educate folks on a variety of different environmental, legal, and policy issues pertaining to our state. Attorneys who are tuning in, if you paid for the CLE credit portion, you will get CLE credit. Just make sure that you do the polling questions during the webinar so that we can track your attendance, and then we will send out a survey form at the end for you to fill out, and then I'll submit your credit to the Ohio Supreme Court. So if you are here for CLE credit, make sure you do those pieces. We are also recording this webinar, and for folks who don't end up attending, we'll send out the recording. It'll be available. Just watching the recording will get you CLE credit, though. So I'm not going to belabor too much more about the start of all this. I'm going to be turning the microphone right over to Justin and Dave from Altman Newman, and they're going to tell you all about the air nuisance rule. Hopefully, this is an informative presentation for you all today. And thanks for joining.
Well, thank you, Chris. And Justin, you feel free to chime in at any time. Robin, if we could get the first slide up. And is there a way to, yeah, there you go. All right. This is the just summarized language of the air nuisance rule in Ohio. And we thought instead of just looking at the, I guess, black and white of print, we would actually try to show you what an air nuisance looks like. And this one is a doozy because it led to the repeal of the air nuisance rule. So let's go to the second slide, Robin. The case involves a couple in southern Ohio who live next to a coke facility. A facility that makes metallurgical coke. And these words are from the transcript of the preliminary injunction hearing on this air nuisance. Jim Sampson, for those of you that are might not be able for one reason or another to see or read this, says with a photo in front of him, I have literally seen thousands upon thousands of pollution clouds come from the coke plant and pass over our home. I've seen coke hazes that come in the direction of our home from the coke plant and enter onto our property. I've seen these clouds of pollution go on over our surrounding neighbors. I've seen the hazes go on up to the back road area, which is an area in the vicinity of his house, which is probably 250 feet from our house and against a hillside. And I've watched those hazes kind of expand along that neighborhood and affect our neighbors. And during a lot of these situations, excuse me, I've lost the bottom of this. During a lot of these situations,
it continues. I'm being exposed to a lot of gas, really foul and rank odors.
All right, so let's go to the next slide, Robin. I call this a really dirty pollution cloud. This is July 24th of 2018. And the hearing was just in September of 2018. So these are leading up to the hearing. I'd like to point out all the different colors in this, which of course we can't see because of the lack of resolution, but in the courtroom, you could actually see on a high resolution screen the colors. You can see the blacks and the grays, but there's a lot of yellow. and you might be able to see if you've really good eyes the yellow. This photo really doesn't do it justice, but it is there. And this is Jim. What what he's also coming to our property, and I'm being affected by this cloud by coughing, hacking, and actually I gagged and threw up at this particular incident. Robin, the next. And this is July 24th, 18. Also in this photo, you can see that on the newer unit that was put under production around 2008, they are also going
I think we may have lost Dave. Right? Is Dave back? All right, Dave, we lost your audio for a second if you want to go back. Oh, Dave is muted.
sometimes they do this process in periods of 2 to 4 hours, and they do it at the same unit, same time on unit, what I call unit 1 and unit 2. So in other words, it's a double whammy. Go to the next one, Robin. And there we have August 26th, just a few weeks before the hearing, early in the morning. And you can see that Jim says uh, that he hadn't been up in a few minutes, opened the door, smelled the rank green, what they call green ovens, into our family room. And I mean, it was rank. So I grabbed my monitor. Now, this monitor, and I'm going to tell you about this in a minute, is the air pollution monitor that Jim was armed with, along with an somewhat renowned air pollution professional that had provided him with a protocol to use this monitor. So I grabbed the monitor and the equipment that I used with it and took it out and put it in position. And immediately I saw numbers were in the red and they were over 100. And what really stuck out to me this morning, besides the pollution and the rankness of the air, was the black sky. I mean, there wasn't a cloud in the sky that morning. Everything was black. And this pollution just illuminated this morning that was coming from the coke plant. And it was just engulfing our neighborhood. And if I know that this morning the PM monitors, the particulate matter monitors, went up into the 120s and the high 120s. And it absolutely, my throat tightened up, started gagging. Once again, I lost it. I had a swig of Mountain Dew when I first got up in the morning. And as you know, I lost it in the yard. He meant threw up in the yard. And then I'm going to let you look at what he says here. On the 26th of August, this is from the transcript, actually the literal transcript from the trial, PI hearing. I had headaches from the time I got up that morning, went outside just after 6, and he goes on about his concern about on his property. He had 6 grandchildren. Some of them were quite young, and how he was concerned about them being exposed to this stuff. And what they had to do, which is vacate their grounds, but the kids are in and out all the time. And Robin, go to the last one. And I ask him, now, why do you take these photos? Well, Jim says, we have to have proof and evidence of what's taking place. But I said, why doesn't someone else take them? I don't want Bobby, that's his wife, to do it. It's terrible. There's days that it's just terrifying to be out on those days, like the 26th of August, when all day long you're seeing elevated readings. This is on the monitor that's causing you to have physical effects. And I just don't want her out there. Now, under the current situation we find ourselves in Ohio, we have to realize that what Jim is doing here and what led to a preliminary injunction hearing and evidence accepted by the court. Of course, obviously, he was cross-examined, did extremely well because there wasn't much way to touch him. All of this information is now subject, and we'll come back to this, to being banned. The monitor that he's using under a protocol designed by a professional can't be considered under this matter that's being challenged, frankly, by the OEC and others in court in Columbus. The entire ability to go to a federal judge is being taken away. And yet, this kind of valuable, irreplaceable evidence is on the verge of being banned in Ohio, even though it's highly probative. And so, with that in mind, we just wanted to show you what an air nuisance looked like. Now, Robin, if we can go to our first slides. And all of this is in the context of the 1970 Clean Air Act amendments, which set up what we call national ambient air quality standards. And there are 6 criteria pollutants: ozone, particulate matter, carbon monoxide, lead, sulfur dioxide, and nitrogen dioxide. And I just want to, you can look at this slide and we'll get you copies of it if you want it, and all the others, including the photos. But let me just focus on particulate matter. A lot of these air nuisance cases include particulate matter, PM 2.5, PM1. And what's so important about the particulate matter? Well, people suddenly realize that these forest fires are coughing up a lot of particulate matter, and then this can get down, if it's a smaller size, really beyond what you can see, it gets deep in your lungs. It is not, it is extraordinarily dangerous, and it's being appreciated around the world by science. And the air nuisance rule of our many cases that we've done, particulate matter, because you tend to be able to see the larger particles, and then you can measure with these monitors the smaller particles, is a particularly good tracer for creating the evidence needed and getting some justice done. Because you couple that evidence with the testimony of the people who are there, usually 24/7. I mean, even if, as in some of these cases, the father in the family drives a truck, or which has been so in many of these, that not that there can't be women truck drivers, of course, but the woman is a home grandmother or mother with the kids. They are exposed. They can make observations. They can keep a log. So anyway, under this federal standard called the NAQS standard, NAQS, the states have to submit state implementation plans to take their various ways of implementing and enforcing the NAQS. and meeting the requirements. Robin, next slide. Now, when a state submits its SIP, or the US EPA must approve, as you see on the slide here, the choice made by the state, and the state's at liberty to adopt a mix of ways to get at this. And Ohio has always had a very important consideration of the air nuisance rule. And let's go to the next slide. We'll get into that, Robin. And the reason, whether your plan and your procedures are in the SIP, the reason that's important is because it makes the entire set of rules that are in the SIP enforceable in federal court. So what you have to do is you write a notice describing the violation, which is not as difficult to do on the air nuisance rule as it is on many other narrower violations. And you send that to the state and to the federal government to see if somebody will take care of it. And usually this is done after you've tried for several years to get your state agency to do something, or you wouldn't be bothering to do a notice because they would have already been enforcing, which they tend not to do. So that's the key thing. By taking the air nuisance rule out of the state implementation plan, you actually are denying the option of going to court to the people who are actually suffering the nuisance, and they have to continue or find another avenue of violation. So, Robin, let's go to the next. There's not any question that the federal court would have jurisdiction over anything in the SIP. And that means they can enjoin or stop the problem, and they can assess civil penalties. Now, when this rule was first taken out of the SIP at the end of the Trump 1 administration, very end of the Trump 1 administration, a bunch of us, including our clients, Marilyn Wall and Donna, had to go to fight all the way up, which took a bit of time. And as a result, the Sierra Club versus EPA suit in 1923 recognized that increased enforcement of public law when the government lacks the resources to handle it is essential to the enforcement of federal law. Now, this has been the policy, at least up to now, of the US EPA. No matter who the president was, they've always recognized the important role of backup enforcement by citizens. Okay, Robin, let's go to the next slide. And at the cornerstone of all this is a very old idea, not new, cornerstone of Ohio's law dating back before the Clean Air Act even. The emission or escape into the open air from any source or sources whatsoever of smoke, ashes, dust, dirt, grime, acids, fumes, gases, and vapors, or any other substance or combination of substances in a manner, and you can read it, that endangers health, safety, and welfare, damages property, is a public nuisance, and it's unlawful to cause or maintain such a nuisance. This was Ohio law before there was a Clean Air Act, and not surprisingly, it was adopted into the SIP from the beginning. Robin, let's go to the next one. Ohio did not accidentally take this thing called the air nuisance rule and put it into Ohio's first submittal. The US EPA approved the inclusion by Ohio deliberately into the SIP, the State Implementation Plan, back in 1974. Now, how do we know this? Well, we found and were aware of an individual who ran the Model Air Agency in Ohio at that time and was pretty renowned, and directly was an advisor to then the Ohio EPA director in 1974. I think that was Ira. But in any event, that's how we know. He said this was a deliberate choice. This was a cornerstone of how we did our law. Every air permit that has ever been issued in Ohio, at least up to now, has had included in its basic terms the air nuisance rule. This has been a cornerstone. All right, Robin, on to the next. And then somebody might say, oh, okay, well, that was a long time ago. Nobody ever gave this thing any thought. It just stuck around. No, that's not true. The ANR, the air nuisance rule, was reapproved when the SIP came up for reconsideration 10 years later in 1984, which is important. That's why they do the reauthorization process, to make sure you still want to do the same thing. Well, in 1984, it was kept in. And then if you zoom all the way forward to 2015, there were some minor changes, and it was still in, and industry wanted to have it removed, so they asked the OEPA, and back at that time, the OEPA rejected the call to remove the ANR. Go ahead. Now, just a few things about why it's a safety net. And I wanted to share with the people that chosen to attend this seminar a little bit about, I guess, the way I look at it. The National Ambient Air Quality Standards for these 6 criteria pollutants are predicated on the idea that in these facilities, large facilities for the most part, but all with a permit and the requirements, that you're going to capture pollution, you're going to put it through your pollution control equipment, and you're going to get it out, distributed, and then there are these monitors out there that will catch the pollution. So the first thing, take the Sampsons. We looked at the nearest monitor to the facility you were seeing in the facility. It's under a group of trees and violates all of the regulation, or nearly all the regulations, that say that monitors have to be able to actually, breathe or suck in the pollution they're monitoring. It's extremely difficult at the closest one here. And this is true a lot of places. And the monitors may have recently been changed, but for years, we told everybody, told the state, told everybody that these monitors couldn't monitor. But here's the most important thing. Whether you have great monitors or not, you've got a situation where if you open a door or do other things that don't prevent the pollution from getting up to your pollution control equipment and then out into the air, these are the cause of many, many of these air pollution, uh, air nuisances. In other words, you simply opening a door. There was years ago a company called Falcom, which I represented our little firm represented a city called St. Bernard, which is really a carve out of Cincinnati, and St. Bernard was bedeviled by this particular facility, which turned out to be, in fairly short order, found out the largest unpermitted polluter. And I took the deposition of the CEO of the guy that literally owned everything. And I said, why didn't you follow the law? He said, I had a chance to grab the brass ring, and I did. It was remarkable testimony. Anyway, of course, that quickly fell under an injunction once we brought it into court. And in that time, the Attorney General's office actually joined our case and worked with us. How things have changed. So simply circumventing the entire process by letting the pollution from your facility escape the facility, thereby creating the air nuisance through just literally opening doors in what should be a negative pressure situation. That's one of the things that we see as the importance of the air nuisance rule, because these nuisances quite often, it's not required, but they quite often are preventing the NACs from being properly monitored. Second of all, the NACs itself, this is inherent in the NACs, is an average, and it doesn't protect the people who live, especially in the fence lines closest to the pollution. And of course, the ANR itself is limited to 6 criteria pollutants. That's what it is, and that's the way it works. But when these things escape, the reason the air nuisance rule is written broadly the way it is everything escapes. So, and some of these things become the tracers for the criteria pollutants that are harder to detect. Now, PM 2.5 is a tracer that is usually one of the easier ones to detect, because almost by definition, you're going to have larger particulate matter along with the smaller. But then I have gone through this historically, and I think it's fair to be accurate. I'm sure there's an air contractor in Ohio, in a region or in a district that's good and does investigations. I can tell you that in 50 some odd years of practicing, and 40 some of them strictly in the environmental area, I haven't found them. So we have had, so what are the problems? Let me just simply say, the problems are that you call your local agency, and we have people like Donna Ballinger, who's one of our clients, who have done this for years to report the problem. A investigator comes out quite often a day or 2 days later, and he or she says, well, we can't detect the nuisance that you reported 2 days ago anymore. Well, of course not. The wind shifted, the operations, but they are required in many places, including here in Hamilton County and many other places, to establish that what you smelled when you called in your report, they can verify. If you use this criteria for any other kind of crime, you would have no crime because you would have to have an officer there to see the crime being committed. That is the way this works. And the reason, by design almost, that you do not have the local agencies able to get there in time to implement the rule, which when they send it to enforcement, they'll ask, well, did you actually experience the same pollution? Indulge me for a minute, and not that you haven't been already, but many years ago, my daughter, when she was about 12 or 13, went out front. I guess she went out to get the newspaper or something. And she came back in. Was a young, very concerned about the environment, and later did some more, created an environmental organization. But she said, Dad, it really smells bad out there. And I thought I knew what the facility was, but I thought, well, let's use this as a teachable moment. So I said, well, Lauren, why don't you call this number and report this? So she did. I said, now, I just want you to know what people go through. So she called up. They said, well, can you wait there for a few hours because it'll take us a while, somewhat understandably, to get there. Well, Lauren said, well, I've got to go to school. I can't skip school to make this report. And they said, oh no, we've got to be able to, what you smelled was actually, we can trace it and look and try to determine where it's coming from. And it needs those to be the same smell. So Lauren said, well, if you come out in 2 hours, let's say, and you smell anything and trace it, I'd be satisfied. She said, no, that wouldn't be a report because you have to smell it and we have to verify it. So she said, oh, I see what you mean. And then for a while I told that story all over, but that literally most places is the way it works. Now, around Jim Sampson's place, the air agency doesn't get there for quite a while, but in one instance, in a prior case before Jim's and Bobby's in the same area, the agency came out and they looked really hard for the problem, and they found 2 days later a dead skunk, and literally in the report on the 2 day earlier pollution issue said it was probably due to the dead skunk. This is one of Justin's and my favorites of all time in terms of how this works. So anyway, shall we call that lax enforcement? I guess if we want to be kind, we might use that phrase. All right, Robin, do you want to go to the next one? So it seemed to me years ago that the simplest and most effective way to get evidence in front of a court that can be weighed, verified, was the air nuisance rule. And these are some of the cases. I guess most of these happen to be, there's Thalchem from the early days, that was years and years ago. I think these happen all to be our cases. Fisher, of course, is out of the Southern District of Ohio, but we got a very good decision that was upheld, one of the early ones on the air nuisance rule, and that was a case we did with able and yeah, up there. Anyway, this slide's available to you, and all of these cases are fascinating cases. But the simple answer, the air component. Now, many of them involve things way beyond and way more expensive than even fixing the air nuisance. They involve some of them involve major cleanups like um, uh, the Hertzler versus Vernay case, for example. That cleanup has been going on, sort of cleanup has been going on for 20 some odd years. But there was an air component to that case. Um, and then ultimately the air sources were totally shut down and removed. Okay, Robin, let's go to the next one. We've already alluded to this earlier, photos, videos, journals. Up to now, these are the things that have been the key to getting to the courthouse subject to cross-examination, and they should be. Um, um, Making formal reports to the Ohio EPA, at least making the report in the more detailed. And then, of course, big use of air monitoring. And if possible, and it's almost necessary, to have a knowledge of what an expert would require, or actually bring the expert in early. These are all the things. These are the components that are very doable that allow you to bring your air nuisance. And Robin, it's also a deterrent. You don't necessarily have to file a lawsuit. If you've got the goods, you, as the Sierra Club has done, can sit down and litigate, or excuse me, negotiate, because some defendants see the handwriting on the wall and want to cut all of their transaction costs by solving a problem, which is a wonderful idea, and the way all companies ought to want to do it, but sadly they don't all want to do it that way. Robin, you want to go to the next one? I already alluded to what's going on. The attempts to dismantle failed, but in 2020, a lawyer went to the team of several lawyers went to the Ohio EPA and the US EPA. They provided a playbook and on how to get the air nuisance rule out. It recommended using completely improperly and illegally the Error Correction Authority, but nonetheless, that was what was done. And that is what happened at the end of the last 5 months, 4 months of the Trump administration, and what led to their withdrawing, and then it led to our crusade to get it back, which after being removed in 2020, it was returned effective earlier in February of 2025, back in for now. But Robin, you want to go to the next one? Now, a new gun, the General Assembly, has been, people have gone to it, and they stuck in without complete violation, we think, of the one subject rule, which has upended a lot of legislation in Ohio, the violations of that rule. They stuck in making it illegal to actually enforce the air nuisance rule, and actually to use monitoring equipment, which is unbelievable, to do it. So, all right, is there another slide here, Robin? Let's go through these. Go to the next one, and we'll provide these for you. Robin, is there another one? let's go. These are all things that have been through the Sixth Circuit. Oh, I'm sorry, I lost that. Put that last one back up. These are things we've already talked about. Um, and I guess the other one I want to tell you about is Donna Ballinger up in around Middletown, around old AK Steel. Donna, series of complaints um, over years, using her air monitor, documenting everything. I guess was told once that the problem, Donna, is that you live next to the plant. This is by the air inspector. And that was the problem, not the pollution, but that Donna, was forced to live there by her circumstances, along with her family and neighbors. Then later, the Ohio EPA said, well, this is an air nuisance. We're going to make the company pay for car washes. Well, it's not the car beautification agency, it's the Environmental Protection Agency. And that kind of cynical thing, of course, stalled our efforts to enforce the law, because you then had a pending enforcement action that gave no meaningful relief. So that's why Donna is waiting for this to be cleared up so a new 60-day notice can be sent. Right now, the Ohio EPA, as a practical matter, isn't going to consider it until we get this case, the OEC and others get this case messed up. So let's show real quickly a few minutes of the video and then turn it over to questions. And we need to get the sound on.
Jessica, you may need to be unmuted for the sound to work. The sound is still not working, which we apologize for the technical difficulties, folks, because the sound did work when we tested it right before this webinar. So we may not be able to feature the video here, Dave.
All right.
We can send it out afterward though if we need to.
Yeah. All right. Basically, there's just 3 minutes worth of video, but it has the real-time voice, and this was all admitted into evidence, and nothing we've shown you today hasn't been in front of the federal court and wasn't admitted into evidence. But Jim Sampson's real-time narration is what we wanted you to hear, and you can listen to it when you get it. But now let's try to turn this over to you to ask your questions.
Yeah, and I'll facilitate that, Dave. We've got a few good questions already in the Q&A. And Jessica just prompted the first poll question for folks that are seeking CLE credit, though if others want to test their basic knowledge as well, feel free to. We'll do another one before we close out as well. But all three of these questions that people have asked so far are really excellent. And let's start with Monica's, which is, do local governments have the standing to bring cases on behalf of their residents under the air nuisance rule?
Justin, I'll handle that one, because absolutely they do. There is no question about it. And I'll tell you a funny thing from years ago when Lee Fisher was Attorney General. And a guy named Jack Van Clay was his deputy. But yes, they do. And it is and one of the first things I did when I started to do nothing but environmental cases was to take on cleaning up the dump sites in the city of Toledo. And we made full and rich use of these on behalf, and very successfully, luckily, and thank God, back at that time, um, um, on behalf of the city of Toledo. Now, did the city of Toledo, according to the newspapers, uh, the Toledo Blade and others, did they suffer criticism for enforcing environmental law? Yes, but that was losing criticism because turns out people do want, at least back at that time, want environmental law. Also, don't forget solid waste districts for some of the laws that made it in the waste areas that need to be enforced. The the funny story is before Ohio's state programs were federally approved, when Lee was Attorney General, he actually publicly agreed with me that the state of Ohio, until they got authorized, was willing, with him as Attorney General, to use the citizen suit provisions because there's nothing to stop a state from doing it. So, and you might think, if the state's laws are inadequate, but there's a federal law being violated, a progressive state, even if it can't get its legislature to change its laws, could use a citizen suit provision. So I hope that answers the question.
Thanks, Dave.
I was just going to chime
So,
in, Chris,
oh, go
with
ahead, Justin. Yeah, go
yeah,
ahead.
just a couple points. Dave's completely correct. Yeah, this local governments have the standing to use it. I think um, as Dave was alluding to, when they do their investigations, what often happens is that they may only seek to enforce the dates of the nuisance where they verified whatever the community reported. So what you often see is maybe a nuisance on 3 or 4 dates, and maybe only looking at the particular causes of those 3 or 4 incidents. And that's a much different than how a community seeks to enforce it, which is take the Sampsons and Gannons for case, for example, the one that Dave was highlighting at the beginning. They've experienced a nuisance for 4 or 5 years, and it's almost an everyday. You can't go outside. You got to keep your windows shut. You got to, you can't go out into your yard without having a terrible headache. So the community looks at the nuisance as a darn near everyday occurrence over 5 years, and so they're looking at it more comprehensively and looking at all the sources and many dates. Whereas there's a real difference with how an agency may often seeks to enforce it by looking at isolated dates. So so they
Boy,
do they can enforce it, but they don't often do it very effectively. So
that's a great point, Justin, because what happens, I mean, obviously, when you do nothing but represent little guys with a big problem, environmental problem, you develop a culture of understanding. What doesn't exist now in law departments and whatnot is a culture of enforcement, being enforcement minded. And that's why you have a narrower views of enforcement. And that's why citizen enforcement remains so full, broader enforcement remains so important.
So the next question that I think we'll lift up here is someone was asking about the kind of the evidentiary standards for evaluating the Sampson's evidence, but maybe also generally any of these cases that are brought. They're asking about what standard was used, and then also what standard do you think should have been used. This question is from Dave. I know you had a slide discussing some of the standards that were used. I don't know if you want to talk a little bit more about the evidentiary standards that are used in evaluating evidence in an air nuisance case, though.
Well, I mean, you've got a preponderance on a lot of issues. Now, um, so Justin, do you want to chime in on this?
Yeah, I mean, in that particular case, I mean, we were obviously trying to establish that this facility was an air nuisance. So we had to show that the facility was causing unreasonable injury to people's ability to use their property, breathe. And so and in that particular case, it was a preliminary injunction. So we were trying to prove that it was likely an air nuisance, that we were likely to succeed in showing that it was an air nuisance under the standard that Dave alluded to earlier. And then we were also trying to show in that particular case, and that's why Jim's some of these videos that maybe that you didn't get to hear, where he's out there standing, holding his air monitor, and has to run inside because he starts to cough and gag while he's being exposed. We're trying to show that air pollution was causing irreparable harm. He's breathing something that presents a threat to his health. And so we used multiple lines of evidence in that, direct testimony of Jim and all of his neighbors, ministers and other people who lived around the Coke plant. We used air monitoring data, and we used an air expert to prove that there was an air nuisance. So that's what that. Sorry about that. That's the evidence we were and what we were trying to show in that air nuisance case. And that's I don't know if there's anything else to add to that, Dave, or not. So and and overall, it the our view is that the evidence that we put in on that particular case was pretty compelling, because it's what ultimately caused industry to go to US EPA and try to get the tool taken out of the SIP. So
Yeah, no, Justin, I I don't think there's too much to add to that.
So I'm going to combine, I think, so we had someone else ask about local governments enforcing air nuisance laws. I think that question was answered, though I guess there's a slightly different uh, spin on it. I guess, are you all aware of any local governments right now that are enforcing air nuisance laws using the ANR rule? I'm guessing no, because it's been in such a nebulous state over the past few
Yeah,
years.
that's the point of clouding all this. You can send a notice out, um, but the federal government is not doing any federal enforcement, which they used to at times, not so much on the air nuisance rule, because that's, they federal government shies away from any kind of nuisance related standards or claims. They just don't deal with it. I guess they don't feel they should get that deep into a community issue, I suppose. But the state government can't, because you just wouldn't be with it, with what's going on. You and the commands from the legislature. That's people don't want to do it anyway. In these, unfortunately, in Ohio, you may have different answers in different states with these situations. But no, I don't know of, and I'm trying to think. I don't know of anything that's going on now, because the judge would be told, "Oh, this is so uncertain, so nebulous, uh, so whatnot, that your 60-day notice wouldn't even, it wouldn't even be looked at by anybody today." And in 60 days, the defendant's attorney would show up and point out that this thing doesn't exist anymore. That's why
So
these cases are so important that OEC and others are bringing, and that we're prepared. We have entered an appearance in the Sixth Circuit to challenge this. The effort to industry is challenging in the Sixth Circuit, but they've asked that it be stayed so that this Ohio legislative angle of destroying the air nuisance rule can be worked out. So right now, the Sixth Circuit stayed with the full support of the Department of Justice and the U.S. EPA because of this gambit with the legislature.
Thanks, Dave. So I think our last poll question should have gone up. Hopefully, people saw it and were able to respond to it. If not, I think we've been tracking people's participation in other ways. We've got about 2 minutes left, so I think I'm going to try and we got some really good questions in here. I'm trying to decide which one we should take to close ourselves out before we kind of wrap things up. I think so. The I think this is the question I want us to close on because I think it's an important one. Obviously, there are the efforts to maintain the air nuisance rule that OEC is a party to. You've mentioned it a few times, but this question I think is important. If the air nuisance rule does go away, hopefully that doesn't happen, but if that is a world where that happens, what are the citizen suit options that will still exist, if any, to kind of fight these sorts of circumstances? Like, what are those tools that people will still have available to them?
Well, there'll be very much more trying to find narrow technical engineering violations. Uh, and that will be, frankly, way more cost intensive than the evidence that fits nuisance evidence. Nuisance evidence is, and common law nuisance, as the Sixth Circuit already pointed out, is not a substitute for the air nuisance rule, but that's what you'll be reduced to.
And I think the other point on that is that the air nuisance rule gets you the more of a holistic evaluation of the facility and a whole better opportunity for a holistic facility-wide remedy because you're evaluating what the facility is doing to the community as opposed to like Dave's talking about fighting it out on individual technical violations. So,
Oh, let me throw in I mean, really the last appropriate note would be this. The most important thing about the air nuisance rule, the reason it levels the playing field and gives hope to the people that I've in our firm, Justin and I in our firm have, is because of the attorney fee provision. We can work for years on these cases, and at the end, we can get our fees and costs back if we substantially prevail. And that may not be a good gamble for a lot of lawyers, but if you really care about what you're doing and you have this opportunity, that makes all the difference. That doesn't exist, but for this, so you're losing that, and that there's no incentive for lawyers that want to make a buck and want a BMW or maybe even want a Kia or something. There's no incentive for them to get involved with these messy, difficult environmental situations against 3 or 4 big law firms that are hired by a polluter. The flimsy reed is often this air news is the citizen suit fee shifting provision that allows, if you substantially prevail, attorney's fees. So that's what you're losing, and you have to do it as a tort suit. You have to find other citizen suit violations, which will likely be far more technical, far narrower, and not give you the scope of relief. That won't inspire the court to give you the scope of relief that you will get if you can introduce the air nuisance. So I don't mean to be negative, but I did not want to lose sight of the importance of that air attorney fee provision, and because we haven't emphasized that today.
Well, thanks, Dave. Justin, any final last thoughts? And before you, well, I'm seeing you shake your head, so no final
nope.
thoughts. We're at 102. Jessica is going to be putting in the chat for attorneys the link to filling out the feedback form. It sounds like we've been having some technical difficulties with the Q&A function. I mean, the polling function. So for attorneys seeking CLE credit, complete the feedback form. That's how we'll be tracking your attendance. You've been logged in the whole time. We can track your attendance that way. We also do love feedback from folks who aren't seeking CLE credit on the content of this session. So absolutely, please feel free to fill it out, even if you're not an attorney. And also, there's a question in there about what topics people would want to learn more about for future webinars from the OEC's Law Center. So definitely, please feel free to let us know what you would want to learn more about, or maybe you have a topic of expertise of your own, and you're like, hey, I'd love to talk about this. If you're an attorney, we'd love to talk with you about that as well. So we really appreciate your time today. We really thank Dave and Justin and the Altman-Newman team and Robin as well from their team for joining us today. And with that, we will close it out. I will be sending the link in an email to folks too. We will send out the recording to everyone, especially those who weren't able to attend. And the video that Dave and Justin wanted to have shown today, we will make sure that file is sent out so people can see that and get that audio. And that'll be in the email that we send out as a follow-up. So once again, thanks for joining us. And I believe the Zoom webinar is going to end the moment Jessica closes it out. So make sure you've clicked that feedback link. Thank you all. Have a good day.